Martin's family now speaking out on the second-degree murder charges filed against the shooter, George Zimmerman. Trayvon's mother, Sabrina Fulton, says she has faith in the judicial system. Here's how she said it on Bill O'Reilly.
I believe in the judicial system, and I believe that he can get a fair trial.
Okay, so it's so much a burden on you, though. I don't know how you're going to get through that. I don't know how you're going to sit there and do that.
Well, how did I get through my son being murdered and the person walked for 44 days?
I know, but you're going to have to relive this through this trial.
Well, I believe in the judicial system, and I believe that he will get his day in court and he complete his case.
Mark Eiglarsh is a former prosecutor. Keith Sullivan is a defense attorney. Gentlemen, thanks for being with us. Mark, under Florida Stand Your Ground law, Zimmerman can seek dismissal of all of the charges in advance by going before a judge to claim that he didn't instigate the fight and he feared for his life. And here's the key. He only has to prove it to the judge by a preponderance of the evidence. That's much lower threshold than, burden of proof beyond a reasonable doubt. What's the likelihood of success on that?
Very, very low. This judge, essentially, who's only been practicing on the bench for 16 months, would have to essentially commit political suicide by saying, you know what, I, on my own, will just simply get rid of this case. I don't see it happening. And I also don't see it happening because the facts are not clear-cut. They're murky. He's the only one who could testify that he allegedly turned his back and then was confronted by Trayvon, which is what I think that he's going to allege, which is the only thing that would get him into the immunity grounds. So I just don't see it happening. I think this case is going to go to trial.
All right, if it goes to trial in front of a jury, the burden shifts to the prosecution, Keith, beyond a reasonable doubt. And if the defendant invokes self-defense, and we anticipate he would maybe take the witness stand and say, look, I subjectively had a reasonable belief of imminent danger of serious bodily injury or death. That's tough for prosecutors to disprove, isn't it?
That's going to be very difficult in this case. And I think Mark is probably right that the judge is not going to get rid of this case at the preliminary hearing stage. But the defense always has the opportunity to renew the self-defense argument before the jury. Right. And if you're the defense attorney, what you have to do is separate out and create two scenarios. The first scenario, which is the initial pursuit of Zimmerman, from Zimmerman to Martin, right, and then a line of demarcation between that and the actual incident. And if you listen to Zimmerman's father last week on this network, right, he described that his son had lost sight of Martin and right, turned around and came back towards the vehicle, and then Martin essentially jumped him from the left side and creating this horrific situation.
Let's assume that Zimmerman takes a witness stand and he says that. I left, I got jumped from behind, and my head was beaten into the ground. Isn't that a fear of serious bodily injury or death that merits using a gun?
Well, legally it may be. Let's assume, and we really are assuming the facts, let's say that Zimmerman was the initial aggressor. Experts, or legal experts as they claim, are dead wrong when they say that the aggressor doesn't get immunity. The aggressor can still get immunity if he turns away from physical contact with the victim, and then the victim then becomes the aggressor, and Zimmerman allegedly is punched, broken his nose, slammed on the ground, and then, yes, he used every reasonable means to escape the harm, but he's on his back and he shoots. That could be a theory, assuming they credit Zimmerman's testimony.
You know, Keith, I was reading through some of the papers released yesterday, the affidavit incidental to the first appearance of George Zimmerman. It portrays him as profiling Trayvon Martin, falsely assuming things, following him and confronting him. So prosecutors, have to believe that they have some substantial evidence in that regard that Martin was the victim here and Zimmerman was the aggressor. What do you think?
Well, Greg, I hope that there's more than what we already know. Because if we're going based on just what's already out in the public domain, it's not enough for second-degree murder, let alone manslaughter.
Yeah.
And that's the difficulty.
Real quick question to both of you. You suspect they'll plead this down to manslaughter, which may be why the prosecutor went for second-degree murder as opposed to manslaughter to begin with?
I would say yes, only if the number of years that accompanies the plea offer with a reduction down to manslaughter is reasonable. If
Okay.
it's still 15 years, 17 years,
Yeah,
no,
it's
they'll go
not.
to trial.
I agree. If it's going to be 10 plus, it's go to trial and run the risk.
All right, gentlemen, we'll wait and see what happens. Thanks very much, Mark I. Glarsh
Thanks, Rick.
and Keith Sullivan. Good to see you.